It's coming across as choppy on this end.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justice of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. The court is open.
Good. The first case we're going to hear today is 2019 P906 Mac Hudson versus Tom Turco. Mr. Hudson, I am Justice Mead. With me today on your panel are Justice Kinder and Justice Hand. You have 15 minutes. You needn't use all of your time. And please tell us what you'd like us to hear.
Good morning, Your Honor. I have sought this appeal based on that the lower court improperly considered facts that were outside of the motion to dismiss, which is governed by the four corners of the complaint. And in doing so, she arrived at some conclusions that were premature to be made at that point. The simple question before the court at the time, the lower court at the time, was whether or not I stated a claim. The defendant had moved for summary judgment, alternatively, motion to dismiss, alternatively, summary judgment. I opposed both the motion to dismiss and alternatively their summary judgment. In doing so, there was a number of affidavits that was presented to the lower court. In legit, what the court did was, in her own decision, she denied the basis of the complaint, saying that I failed to state a claim. But in doing so, she relied on the defendant's affidavits that were outside of the four corners of the complaint to say that they stated a penological interest in doing some of the things that they did. Well, and also, there were some issues that the lower court did not even consider, like the Haverty claim that was raised. So I understand that defendants argued, at least appellees argued in their brief, and I countered that in my reply brief that the court must have converted the issue into a summary judgment, which I say in return 3 points. One, this is rebutted by the court's own decision. When she handwritten, it said that she denied it based on that I failed to state a claim. The other thing is that it was too premature. And issues that I raised, the record had to be developed, and I did seek discovery at the time in order to develop that record, and that was part of my opposition to in the lower court to try to prevent the summary judgment aspect if the court even thought of going that way. So an example of that is in Haverty, in the Haverty versus Commissioner, which I'm challenging the restrictive units in the way that SBCC is running what I call otherwise gang units and what they are calling pretextually population units. This was an issue that was dealt with in Haverty. But under Longville versus Commissioner, it says that you have to have the operation manuals in order to assess whether or not that these two conditions actually mirror Department of Segregation unit to warrant minimum due process. So the court wasn't in position to make that judgment. The same problem occurs with the religious claims under the RUPA and under the First Amendment. As I raised those claims were undeveloped, and we could not, or I could not have established at that point, right, whether or not they was affording me the least restrictiveness, or whether or not I could satisfy the Turner versus Safley for purposes of a First Amendment violation, because the record was controlled.
Mr. Hudson, it's my understanding that you're no longer at Sousa Baranowski. Is that correct?
Yes, I'm no longer at, but Sousa Baranowski is the maximum security prison.
Right.
And at any given, I'm sorry, do you have a question?
I do. Thank you.
Okay.
The department's position that because you're no longer there, to the extent you're seeking injunctive relief, it is moot.
Yes, I understand that they argue that, Your Honor, but I believe that this court has said in a previous decision, Wright versus Commission of Corrections, where they raised the same question about Wright being transferred from Concord to SBCC, and that his claims were no longer alive when they was moved. Well, this court had took the position in that case to say that because he was subject to be transferred back, that they were still alive. And I think situationally, I'm in that same category where Sousa Baranowski is the only maximum security prison in Massachusetts. And at any given time, under the commissioner's authority, the commissioner at any whim could just put me in the max. I don't even have to have a classification hearing, but he can put me in the max and then give me a classification hearing subsequently after that action. Given that factor, this is considered the ordinary consequence of being in prison. So the likeliness is that maybe at one time or another you will return to the max. And therefore, I'm saying that the issues are alive. The other thing I would say, Your Honor, to that point, is that I raised constitutional violations in which I sought damages. And those damages would still be alive for the purposes of those violations in regards to habity, in regards to the First Amendment speech that I raised, where I sought nominal damages in that regard. So there are some issues, and then in the point of challenging the mail aspect of it, well, they're still holding on to the material in which is under review by the court. So that issue is still live, and I would say just to the last point in that is that given the glitter issue in which I'm challenging, Your Honor, is that I'm challenging that it's an exaggerated response because what they're saying, first of all, it's a statewide practice that they implemented throughout the whole Department of Corrections. So everywhere is affected this way, and that still is a live issue. So I just want to say that to the court first. But the other thing is that what they're categorizing as glitter, or for the purposes, is a drug called glitter. When you look at their own exhibits, the drug looks nothing like actual glitter. It's just a street name called that. But what they have done is turned around and barred all types of glitter. Now, I know that might seem insignificant on its face, but when you have kids or you have nieces and nephews who write and who do their school assignments and they happen to have these things on it, and you're denied access as a result of that, well, then it turns into a very significant thing from a prisoner's point of view. Is there any other questions before I proceed?
Go right ahead.
Could I actually ask one question? This is Judge Hand. With respect to the legal mail argument that you make, are you aware, not the content, but are you aware of what the substance of the mail that was sent to you and withheld as excessive legal, what that was?
I'm sorry, I couldn't make out everything that you said, Your Honor.
I'm asking a question about the mail that was withheld to you on the grounds that it was excessive legal. Do you know what was included in that mailing? In other words, was it legal research materials, letters, something else? What was the substance of what was there? Not the content, just the substance.
Okay, the substance of it was legal material that I was accessing, that I had access from the streets because I couldn't afford to do it any other way.
Like research materials? Is that what I'm trying to understand? Was it? Okay.
Yes, it was research material, Your Honor.
So copies of statutes, for example, that kind of thing?
Yes, like somebody pulled publications or motions from the court's docket and sent it to me.
Thank you.
But as far as in that regard, and I don't want to reiterate what I already said in the brief, but just to give the court an example of these things. First, my problem is first and foremost is that they just had a public hearing in which if this was something that they was contemplating that they wanted to change, to say that we no longer could do that because we have been doing this since I've been in prison, which is 31 years now. So this has never been a problem. In other institutions like me, while here, it's the same thing. There's no problem with us receiving that type of material, because there's the understanding that if we're acting pro se, we sometimes send our legal mail home, and then we have to have the means to send it back if those of us who have a home, right? Some of us don't have that, so they have legal storage. But in other instances, where we're researching our cases and trying to get an adequate review, some of us might have some folks out there that do that type of research for us or was willing to go down to the court and grab certain documents or what have you. So these are not like printouts that was taken from a computer or nothing, but these were actually documents, police reports, things of that nature, in which, and as you can see, they marked it down as legal work. So even the property officer, the mail officer, when she marked it down as legal work because it was legal material. So she recognized the substance of that. They have all other means to ensure that there's no contraband being, sent in. This is something that would have been developed as part of the record for purposes of a summary judgment if we would have made it that far. But given the facts, we didn't make it that far. So subsequently, to wrap it up, to conclude, I believe that the court improperly dismissed it because for the purposes of that, I did state a First Amendment violation. I stated a RUPA violation. The complaint clearly sets those issues out. I stated arbitrary application of the mail regulations and the not following the procedures of the Administrative Procedure Act to adopt new rules suddenly, right? So this complaint does set those claims out clearly, and then there's established law that says, for instance, even with the First Amendment space, and I just want to clarify for the court this one thing. The argument is not about tape, as the defendants have, or the appellees have made it. The argument is about not having the means to exercise the First Amendment right, in which they recognize and give us the designated area to do that. Now, the court in Lobo versus Northeastern Correctional Center, I've already established that we have a First Amendment right to have that expression where there's no penological interest. And that is recognized. That's recognized in their own procedural policies, which they have. Now, when you look at the grievances that's associated...
Could I interrupt you? I apologize, Mr. Hudson, for interrupting you, but can I ask one other question? This is Judge Handigan.
Sure.
With respect to the First Amendment claim about the freedom of expression as to the designated wall space, are you arguing that there was no other, once the tape was eliminated from the commissary, there was no other way to utilize that space?
Well, yes, they give us a designated area, so I'm arguing that area, if we hang anything outside of that area, it's a disciplinary violation. So they don't give us the means to hang something up there. If you look at examine the grievance that was denied, they said that they was going to provide some means at a certain point, in which I showed they made several changes to the canteen, and still that never happened. To this day, Your Honor, they still do not have a means, they still do not provide men a means in the max to hang their political, religious expressions up. So there was never no intent by them to provide us a means. And so this was something which this came across as quite clear. Is there any other questions?
No. You have a minute and 20 seconds.
I'm sorry, you said 20 seconds?
1 minute and 15 seconds.
Okay. Well, with that, as I said, all the issues that I raised, I've stated a claim in which relief could be granted, and I'm asking the court to remand the case back downstairs for further proceedings because of that fact, and so that we can proceed with discovery. Thank you, Your Honor.
Thank you, Mr. Hudson.
Mute, so.
Sorry, just taking me a minute. Okay.
Welcome to the appeals court. The panel today is myself, Justice Mead, Justice Kinder, and Justice Hand. The next case is 2019 P. Commonwealth versus Rivera. Mr. Suchecki.
Good morning, Your Honors. Mr. Rivera, our feeling is that his judgment should be reversed based on insufficient evidence and prosecutorial misconduct in closing argument. The Commonwealth, Mr. Rivera was found in an automobile, and he was not the owner of the automobile, and there was a significant amount of heroin found in the automobile, but it was only found with the aid of a drug sniffing dog. So Mr. Rivera had really no connection to the heroin. No knowledge was proven by the Commonwealth in any sense that Mr. Rivera had. When during the course of the trial, the judge allowed in conversations between an unknown female and an informant that supposedly somehow involved Mr. Rivera. Mr. Rivera's name was never mentioned in those conversations. Those conversations referenced a he, and that he presumably was Mr. Rivera. During the course of the conversation, they make references to, they don't even say drugs, but references to things that the jury would have to make certain assumptions that there were drugs, what the unit of measure of the drugs were, implying inference on inference, ultimately believed that the person they were talking about was Mr. Rivera. Mr. Rivera, in an analogous case, Moviles, again, an informant informed police that a car would be in a certain location, same make and model. He shows up, but in Moviles, the defendant is found with a small quantity of cocaine. In this case, there's no evidence of Mr. Rivera having any connection to heroin whatsoever. The plus factors, there are certain plus factors that the Commonwealth would need to prove in order to prove constructive possession, in addition to the fact that he was just the driver of the car.
Mr. Suchecki, let me interject a question if I could. Don't the plus factors in this case include evidence of flight and also expert testimony regarding the likelihood that a drug dealer would release a vehicle with over 300 grams of cocaine or heroin to a non-participant in a drug enterprise?
Well, to address the whole idea that an expert testified that drug dealers do certain things doesn't mean that Mr. Rivera was a drug dealer. The plus factor, I'm sorry, what was your first one?
Well, the first question had to do with the plus factor of the evidence of flight.
Well, Your Honor, now I do have, if you look at the police testimony, there are contradictions in there. There are only 4 officers who testify. And the scene that day was just to set the scene. And the Commonwealth in their brief and also at trial tried to imply that there was a high rate of speed and flight. And what it was Trooper Larry Richardson said it was March of 2015. It was snowing every 3rd day. There were huge snowbanks. The pretty wide street basically was down to 1 lane. So what actually happened was and further testimony from some of the officers that they were miffed that they couldn't get into the slow line of moving traffic. So what you have is Mr. Rivera on the street and police officers behind and in front in unmarked vehicles. And those unmarked vehicles prohibited, I mean, he had no movement to go. Now, a plus factor could be, was it evidence of flight? Evidence that he did something once people approached him that
they had activated the lights on the police cars, right?
Well, That's also, and it doesn't, they don't say whether the lights are on top or in the window, and they were unmarked.
Those are conflicts that don't create a sufficiency claim. They're to be resolved by the jury.
Correct, Your Honor, but they're also inform your decision, Your Honor. The fact is that.
But we have to look at the evidence in the light most favorable to the Commonwealth, not light most favorable to the defendant.
Right, correct, Your Honor. So even if you give that plus factor, you have possibility of evidence of movement on that street once he sees people approaching. Now, the Commonwealth says that they had their badge displayed on lanyards. Clearly, it's snowing outside, or there's high volume of snow, so they're wearing presumably winter coats, and they're converging on a vehicle. And it's just as conceivable as Mr. Rivera sees a large amount of people converging on his vehicle and wants to get out of there, and has nothing to do with any drugs, has nothing to do with anything, but maybe he has an immigration issue, an outstanding warrant, any number of reasons why he doesn't want to.
Again, that doesn't view the evidence in the light most favorable to the Commonwealth.
Well, if I grant you the concession that there's possibility of flight, that and him being in proximity of the heroin, I don't feel is enough for a sufficiency argument, because it still requires a leap of faith that he's driving that car and somehow he has access to the drugs. There's no evidence whatsoever. Now, as far as my first point in terms of the conversations, Mr. Rivera had no cell phone. During the conversations that the judge admitted into trial, there's a conversation that the woman who's talking says, "I'll get back to him." They arrange a meeting, and during the many conversations, she keeps saying that she'll talk to him. Mr. Rivera has no cell phone. There's no way for him to communicate.
Do you agree, Mr. Suchecki, that the defendant does appear at the location of a prearranged meeting and is seen walking up and down as if he's looking for someone?
Well, what is as if he's looking for someone mean? He could be looking for his dog. He could be.
Well, wasn't that the testimony though?
The testimony, the police officer said as if he was looking for someone, but what is that? It could be looking for anything. It doesn't, he just, inserts someone.
Well, if the jury credited that and also credited the fact that he was the only person in the car that contained that amount of heroin and coupled it with the testimony of the expert, why wouldn't that be sufficient?
I think that you're still needing conjecture and surmise. He's just walking. It's not a crime to be walking in an area that a drug deal was arranged to be had. He's just walking around looking. He may be looking for someone, but that's not a crime. That's not suspicious activity in and of itself. And if you credit that he showed up at a location, well, was the Riverfront Park location? It wasn't specified. It was very unclear based on the conversations that were admitted evidence where the exact location was. And when he does go back to his car and he gets in the car and pulls into traffic, they converge on him. So there's just not enough proof that there is knowledge. And the most important thing in constructive possession is you have to prove that the defendant had knowledge and the intent to exercise dominion and control of the drugs. There's no evidence he had any connection to drugs. A plus factor is oftentimes money. Mr. Rivera had $40 in his pocket, $40, no cell phone, no way to communicate with this person who he supposedly set up this meeting with. It's just as possible that he was set up by somebody, or he was told by, these conversations took place over a long period of time. Maybe the actual dealer got cold feet and told him to just drive over there just to kind of feel out the thing and see what was happening. In addition to that, Your Honors, the prosecutorial misconduct in closing argument, we also feel is a legitimate reason to overturn this case. The prosecutor clearly misstated the evidence and on several occasions said directly that the car was owned by Mr. Rivera. There was absolutely no proof that Mr. Rivera had any connection to that vehicle.
I recall the evidence being, or the argument being, that it was his car.
Correct, Your Honor.
That's a little bit different than talking about ownership.
Oh, no, Your Honor. There's actually, she went on 3 different occasions during that, and she said essentially that it was his car. Unfortunately for him, the road was narrow with snowbanks that were built up high, and the street was full of unmarked cars. So he got caught. Not only did he get caught and stopped, the police were able to find the hide in his car and find the drugs inside of it. That's on volume 4, page 30. She went on to argue, And how else is he avoiding detection? He's driving around in a car that he had somebody else register. You heard from Trooper Clemens, you heard from Trooper Richardson. That's what drug dealers do. There's no evidence that he had, they actually had the name of the person who the car was registered to. So if that was actually true, they could have had her testify. They had people.
That's a little bit different, isn't it? The fact that they could have had her testify.
Correct, that's why I'm saying.
I guess the question, if you could pardon me for just a minute, Mr. Suchecki, the question I have is whether or not that wasn't a fair response to a fairly powerful argument by defense counsel that the defendant had nothing to do with the car.
No, Your Honor, I don't think that's a fair argument. And this is clearly a misstatement of fact. And the third time, she said he's driving a car that he had somebody else register, but then she says it was a hide in his car. Now that's not an accident. One is excusable, two not so much, three inexcusable, irreversible, because you're telling the jury, and the jury mid deliberations literally asked the question of the case: can somebody in a car who doesn't have knowledge of the car be guilty of possession? And that's the jury question. That goes to the heart of the case. So Perez goes through the number of factors, and every single one of those factors, it shows that this was so prejudicial that it goes to the heart of the case, that it was a misstatement of fact. And as far as rebuttal goes, a fair rebuttal is one thing, but to actually say that his car, there's no evidence of that. He was driving the car, yes. It took the police officers who had a real interest in finding the drugs in the car could not find it. They summoned a police dog. The police dog couldn't find anything in the first round with the hood open. It jumped on the engine block and found it. And they used a crowbar to get the drugs out. So even interested parties couldn't find the drugs when they wanted to. And to imply that Mr. Rivera, who presumably, if reading the fair reference from the evidence, was just the driver. And a driver in and of itself cannot be in possession and proven constructive possession. There's no identifying papers. There's nothing that says that it was his car. There's no cell phone. There's no pagers. All the usual accoutrements of somehow being associated with it. Even the phone conversations have nothing to do with it. His name's not mentioned. He does not make it Mr. Rivera. It could be John Doe. It could be anybody. If there's a possibility that there's a third party here, the person that the woman's talking to on the phone, she was clearly talking to somebody. But if Mr. Rivera didn't have a phone, she wasn't talking to him. Even the Commonwealth concedes in their brief that the conversations were ongoing while the police were on the scene. So somebody was talking to that woman, and the implication is that was Ms. Rivera, but he has no way to contact them. There's no proof that he had. So every piece of evidence regarding those calls should have not even come in because he didn't have a phone. So the knowledge element is absolutely essential here. And there's no proof that Mr. Rivera had any knowledge of any heroin anywhere in the transcripts.
Mr. Suchecki, could I ask a couple of questions? First, with respect, just so I'm clear, with respect to the calls that you say should not have come in, you're not appealing that. Is that correct? Okay.
No.
And what, if any, significance do you give to the visible evidence of the hide from the interior portion of the car, the evidence of that hide?
That's how it was worn and of the like?
The seatbelt strapping in an unusual location by the ankle of the driver and the non-factory screws.
If you read the testimony, the police even had to, that was not easily apparent. So if you're getting into a car and driving a car, you're not looking for a hide underneath the steering column. It was clearly difficult for the police to find. And if I recall correctly, that seems to be something they discovered ex post facto, that it wasn't, they didn't immediately discover the post-market alterations to the vehicle. So it wasn't readily apparent. So if you're borrowing a car and driving a car, you're not looking at the engine column to see if there's a hide there, you're just driving the car. So even if he was set up, or even if he's somebody else other than the dealer, he has no way of knowing it's hide. There's no proof that he had any knowledge of any heroin anywhere, or that he talked to anybody about heroin anywhere. There's just no proof of it. And their job was to prove knowledge. And you don't want to be result oriented where you go, oh, but this was found here. No, they still have to prove their case. And they didn't prove that there was sufficient evidence that he had any knowledge of heroin, and he had any ability to exercise dominion and control over that heroin. He was in a car that had heroin. They needed a dog to get it, and they needed a crowbar to get that heroin out of the car. So if there's no further questions, there are other issues in closing argument, including her expressions of opinion of the evidence. And also in that is as like a take it from me attitude, which implies that, and this is a substantial likelihood of miscarriage of justice, but it's also, it goes to the non-mistake of saying it's his car. It's the same kind of vein that you got to be kidding me. He knew that it was in the car, and it was still error to do that. So it's our belief, based on these facts and the thin level of proof in this case, that the judgment should be reversed and verdict set aside. So if there's no further questions, I'll rest on the rest of my brief.
Thank you.
Thank you.
Ms. Leary.
Good morning. May it please the court, Catherine Leary on behalf of the Commonwealth. To start with the sufficiency claim, here, this wasn't just a case of the defendant being the sole occupant and driver in close proximity to where the hide was located. The jury also heard evidence from expert testimony regarding the value of the heroin found in the hide and the fact that hides, in fact, are valuable to help them along the path to finding sufficiencies. That drug dealer wouldn't just necessarily let anybody take a car with this amount of valuable heroin in it. But above and beyond that, what is the true plus factor here are the defendant's actions and behavior. One, before he was stopped, in where the officers observed him for approximately an hour in the time and location of a setup drug deal, pacing up and down the street for 10 minutes on what was described as a frigid day with no foot traffic, apparently looking for somebody, as well as circling in the Jeep in that area. And second, where when the police officers activated their lights, the defendant is described as on volume 3, page 16, as soon as the cars came up behind him with the lights, he tried to make a, quote, bankrupt 3-point turn in the middle of the street, pulling into a snowbank. And it was also described as accelerating at a high rate of speed, backing up, and that's at volume 3, page 34. So the fact that he had this reaction to the police officers descending upon him was highly relevant to the fact that he knew something was in that car, along with those other plus factors. And I would point to the Alicia case, which is 410 Massachusetts 384, 1991 case, where the court found it was very important that the defendant's behavior before the drugs were found and the change demeanor and evasiveness is a very big plus factor. And that was recently reaffirmed in Santana 95 Mass App Court 265, 2019, reaffirming that principle from Alicia. So based on that, as well as as Justice Hand noted, that as the driver, the jury saw pictures of this as well, would necessarily see when you're getting in to put your foot on the gas pedal or brake, these seatbelt straps underneath where the steering wheel is. I think common sense and jury's life experience would necessarily know that that might be something you would notice as well. So based on all those factors, on the totality of the circumstance, the evidence was sufficient. If the court has no further questions about the sufficiency, I would just briefly address the comment about misstating the evidence, that the prosecutor the fact that she said this is his car, that's a fair inference from the evidence, as the judge noted when overruling the objection. The fact that he was driving the car, was the sole occupant of it, the fact that he behaved in a way consistent with the way drug dealers behave, that they had expert testimony that drug dealers typically register to third parties to avoid detection. All these actions, when taken together, all this evidence, it's fair for her to argue that he was able to exercise dominion and control of that car and that it was his car. And the defendant takes issue with a lot of the prosecutor's statements, but she's arguing the evidence in the light most favorable to the Commonwealth, which he is entitled to do. If the court has no further questions, I'm happy to rest on my brief.
Seeing none, we thank you. We'll take this under advice. Welcome to the appeals court. The next case is 2019 P1405, Commonwealth versus Delgado. Mr. Juarez.
Good morning. May it please the court, my name is Michael Juarez, and I represent the defendant in this case, Cesar Delgado. This case is about whether the motion judge abused her discretion when she denied his motion for a new trial. I'm arguing that she abused her discretion in the way that she weighed the factors leading towards her finding of no prejudice. She did find a violation here during the plea colloquy where the judge failed to inform Mr. Delgado of the possibility of a life sentence should he violate probation under Mass Rule Criminal Procedure 12C3. The first area that I deal with in this case is the fact that she held it to be implausible that Mr. Delgado would not have pled, Mr. Delgado would not have pled guilty that day, that he was certain to plead guilty. I think this case here differs in light of Rodriguez and Murphy. This is a case here where Mr. Delgado made a sworn affirmation of legal innocence. He had a case that his trial attorney believed to be triable, that they were prepared for the defense, that also that he was prepared to testify on his own behalf at trial. But he was greatly concerned about the risk of a very lengthy prison term based on the charges against him. On October 2nd of 2000, he came to court and his lawyer told him, I think we can work something out for a 3 to 5 year term of incarceration with maybe 3 years of probation afterward. That the DA made a disparate recommendation seeking a much longer term, seeking 5 to 8 years, and 8 to 10 years with 10 years of probation. Mr. Delgado indicated that would be unacceptable. That's in trial counsel's affidavit, saying specifically that he did not want to serve a long prison term and would instead choose to proceed to trial, which a trial was something that they were ready to do. They had discussed and prepared to do it on that day. The case went to Judge Laureate to mediate between them, and ultimately was continued to the next day, where Mr. Delgado was able to plead to something he believed was acceptable, which was 5 years to 5 years and a day in prison with 10 years of probation on and after. He would not, though, according to his lawyer, have pled if he would have had a lengthy prison term. And
can I ask a question? The sentencing didn't occur the same day as the plea, right?
I don't believe so. No.
It was a few days afterwards, or?
It may have been in the afternoon, I think, of the same day.
All right. Well, the defendant did get essentially the 12C warning at sentencing, right?
He did, yes.
He did, and then if he was concerned about facing the maximum that you say would have guided his decision to reject the plea and go to trial, why did he wait 17 years to file a motion for new trial?
Well, I think there's a couple of reasons why. I mean, first, there is the fact that he didn't actually get knowledge that he could be sentenced to a term of up to life until 2011, when the revocation proceeding was. Also, he didn't know that he was supposed to be advised until we filed this motion of that at the colloquy itself. But the issue did not present itself.
Whether he was supposed to or not, he was advised, maybe even that same day.
It's when he first got counsel, for myself, we looked at the case, I realized that he had not been advised by a lawyer or the court of his right to a sentence appeal. Even though time had passed, we sought leave of the court, and we were able to have a sentence appeal. The sentence appeal was done as well. So we were challenging this, for a couple of years now. I've been on this case with Mr. Delgado, and then we filed the motion for a new trial as well on this case afterward, when we recognized that violation as well. But he was incarcerated initially for the period of 5 years. He served that period, he was released, and then not till 2000, when he violated probation, that's when he learned that he could actually be sentenced to something that he was trying to avoid by making the plea that he made that day.
Mr. Warriors, Judge Tutman was the motion judge, correct, on the motion for new trial?
Yes, that's correct.
And didn't your client testify at that hearing regarding his level of knowledge and his motivation at the time?
He did, yes.
And don't we defer to Judge Tutman's credibility assessments regarding witnesses that appear at a hearing?
I think if it comes to finding certain facts, yes, but a lot of the facts are also corroborated by his trial attorney. And there's no mention in her decision that the trial attorney here was not credible for some reason, or that whether it was a lack of memory or whatever it was, there's no credibility determination. But trial attorney was, had recollections of certain events that happened, was clear that Mr. Delgado appeared with concern about going to trial and receiving a lengthy sentence if he lost. And a way to minimize that risk that they discussed was to enter into some sort of plea agreement. And if that materialized, he would consider it and possibly accept it. And if not, he would go to trial. But this would be, I believe, when you read under Murphy and Rodriguez, this would be with the special circumstances that they're talking about, when it deals with, do we have a just result here, or did an injustice occur? That if he would have known this at the time, based on these other circumstances, what would he have done? Now, Murphy and Rodriguez are very interesting by this court, because while finding a violation of 12C3, they don't find prejudice, they don't find an injustice. In those cases, the defendants did not assert actual legal innocence, that they didn't have cases that were able to go to trial. I believe in Mr. Murphy's case, he's even indicated he was present for the home invasion, but that they didn't have meritorious defenses. Here we have a case where trial counsel avers that he was prepared for trial, that it was a reasonable tactical decision to go to trial, that they had strong defenses, that the government's case was not overwhelming. It lacked physical evidence, it lacked eyewitnesses, it lacked corroboration of the victim's statements. At the hearing itself, the Commonwealth relied for the facts on the facts that were from the tender. They didn't produce to the judge, videos of any sort of interviews with the victims for the judge to assess, the victim's credibility in a video. They didn't produce affidavits from counsel at the time about their recollections of the plea negotiations. So we're relying here on what trial counsel recalled, and he recalled preparing a case for trial, discussing the risk with the defendant. We're trying to lobby on behalf for the defendant's best result, and then ultimately accepting a plea where it was possible to do so.
But counsel, couldn't the Judge Tutman have concluded what she concluded without discrediting Attorney Daly's affidavit?
In this case, I don't believe so. I think that she's finding it implausible that he would not have entered into this plea, that he had to do it. He was forced into this because of the overwhelming evidence of the case. Almost, it seems that the government's assertion at the colloquy was so strong that I guess guilt was a foregone conclusion. And trial counsel absolutely said the otherwise, and he dictated.
Again, you remember though, at the colloquy, the defendant admits the truth of all of the extremely detailed allegations that the assistant district attorney read into the record, right?
That's correct.
The defendant admits his guilt in open court to all of the detailed charges. And then later, he files an affidavit that says he's actually innocent, and the judge decides to discredit that. This is just like Hiskins, isn't it not?
It's similar, yes. The difference here we have also, though, we have trial counsel, who's corroborating very important details of Mr. Delgado's own testimony. And Hiskin doesn't say, though, that as a per se rule, this court has to only accept an admission to the factual basis. It does provide it to give it some heightened importance, but not an importance that outweighs many other factors. And here,
I think that Hiskin highlights the solemnity of the event of the plea, and it's not a meaningless gesture in which the defendant gets to cross his fingers behind his back in hopes to later withdraw his plea, in this case, 17 years later.
Well, Bridgman would also say that defendants have plead for a variety of reasons. There's studies and many articles about that defendants who are innocent do in fact plead guilty. And that part of it is risk mitigation in a case. And we need to look at what his defenses would have been at trial, and did he have a viable case to go forward at trial? And this was what this court articulated very clearly in Murphy and in Rodriguez. In those cases, the defendants did not meet their burden of showing special circumstances that the case ended up being an injustice because of what occurred. But in this case, we have a very disparate fact pattern that we had in Murphy and we had in Rodriguez. And in this case, the facts suggest that there were special circumstances that the defense could take into consideration, and that if he was not finding a deal that was acceptable to him, he did have a reasonable decision to go to a trial. This was not, a foregone conclusion. He was not, a person who made an admission that he would participate in the robbery or was on the video of the robbery. This is something totally different that we have with, allegations, and he could have also testified about his recollection of what occurred at the house. This was a house that was not exactly as it was stated, by the Commonwealth at the colloquy. This was a house with dysfunctional family. This was a father who no longer lived with the family. Mr. Delgado moved into that situation. He was warned by the mother that the older daughter was not going to be very receptive to him. They was a family where the mother and Mr. Delgado abused drugs and alcohol. The daughter was old enough to understand what was going on. It caused a very strong rift in the family, that there was a bias and for her to fabricate these allegations to keep Mr. Delgado out of her life. And there were no allegations until Mr. Delgado was jailed in a case where he ended up being shown to be a misidentity. He was released. He comes back to the family. He realizes that the mother has a new boyfriend. To collect his things, the daughter has seen him back over at the house, and these allegations materialized shortly during that period. So
do I recall correctly that there was more than one victim in this case?
There was an older daughter and a younger daughter, yes.
And do I also recall that Judge Tutman, in considering the strength of the case and the likelihood that your client would have proceeded to trial, considered the fact that there were multiple victims who would testify?
Yes, she did. She considered, I think, everything from the colloquy itself that was given by the government. Yes. If there are no further questions, I'll rest on my brief.
Thank you. Ms. Langford. You need to unmute your mic.
Thank you. My apologies to the court. Good morning. May it please the court. Jessica Langsam, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. Justice Tutman properly exercised discretion in denying the defendant's motion. And the judge both cited the pertinent law, applied the law correctly, and her decision was based, as the court has already ascertained, upon a review of the very, I think she termed it, probing and thorough colloquy that Justice Laureate conducted on October 3rd of 2000. And the defendant's credibility at the evidentiary hearing that before her, and where she determined that the defendant was not credible, a determination that this court accepts. And while Justice Tutman recognized that the defendant had not been advised at the colloquy of the 12C3, under 12C3, that if he violated probation, he could be sentenced to up to life in prison on each of the 4 counts of rape of a child. The court also concluded, having listened to and evaluated the defendant's testimony on direct and cross-examination, that there was, quote unquote, no plausible evidence that if the defendant had received that advisement, that he would have preferred to go to trial instead of entering the plea. And the court properly recognized this 17-year delay between, the time the defendant was informed. And with respect to your question, Your Honor, the sentencing took place at 2:00 that afternoon after the colloquy. And it was at record appendix at page 128, where Justice Laureate gave the 12C3 advisement. And that's when the court talked about that this would be a terrible sword hanging over the defendant's head. So there was a 17-year delay between the time that the defendant heard that on October 3rd of 2000 and the filing of this motion. And Justice Tutman also noted that the defendant only filed his motion after he had been sentenced, as has already been discussed, to this lengthy term following his second probation violation. That was a proceeding before Justice Liu on June 2nd of 2011, where he imposed a sentence of 4 to 20 years. And that had been the issue of a separate appeal before this court. Further, having evaluated the defendant's credibility, Justice Tutman concluded that the defendant's claims of factual innocence and that he lied at the plea colloquy before Justice Laureate were not credible in light of the evidence that had been presented by the assistant district attorney at the time, that was Assistant District Attorney Kevin Ryle, and by the defendant's sworn statements at the colloquy. Now, the evidence that was presented by ADA Ryle as to these crimes that were perpetrated upon the 2 child victims is set out in the colloquy transcript, and I won't repeat it here, but it began when one victim was 10 years old and the other was 7 years old. And the abuse continued over 6 years from 1989 to 1994. The victims separately disclosed, as the court has already remarked, and the victims also described in detail this repeated violent sexual assaults the defendant had perpetrated on them. Further, as court recognizes from the transcript of the plea colloquy, the defendant, and as Justice Tutman recognized, the defendant admitted that he committed the acts as described by ADA Ryle. He acknowledged that by pleading guilty, he was admitting that those facts were true, and he affirmed that he was pleading guilty because he was guilty and for no other reason. And that's at the record appendix at pages 102 to 104. And Justice Tutman cites Hiskin for that proposition that the court has mentioned, and that the defendant's sworn statements can't be discarded later on a later assertion that he had his fingers crossed at the time. Finally, Justice Tutman rejected the defendant's claims that he entered the plea because he believed that Attorney Daly was not ready for trial and because he somehow felt manipulated by Attorney Daly. Again, with respect to this, Justice Tutman looked at the colloquy that Justice Laureate had conducted and at the defendant's sworn statements at the plea colloquy that he was satisfied with defense counsel Daly, and that he believed that Attorney Daly had acted in his best interest, and that's at the record appendix at page 104. And unless the court has any questions, I'd ask that Justice Tutman's order be affirmed, and I would rest on my brief.
Seeing none.
In fact, a report they commissioned was released last week confirming that racial injustice is within the law. There's
Ms. Wood?
Yes.
Did the racial injustice claim that you make in your reply brief wasn't raised in on appeal in your opening brief, correct?
So I agree it wasn't litigated below at trial, and it wasn't brought out in the appeal brief, but it was in response to some of the plus factors that the Commonwealth had asserted in its brief. And those plus factors have to do with race, and that's where we have brought the argument in. So generally, I get that there was no race factor asserted below, but just because of the, there's just a heightened time of responsibility that this court just needs to be aware that there's a systematic problem and that they're responsible for ensuring equal treatment under the law. There was insufficient evidence Mr. Desir knowingly possessed a firearm or ammunition or had the requisite intent to control or the ability to control. Presence alone is not enough to prove possession. Driving by an area where a firearm and ammunition was found does not support intent to control. There was insufficient plus factors to show presence and awareness and intent to control the firearm and the ammunition. The evidence here was slight and not sufficient to support the elements, and too often relied upon was conjecture and speculation and facts and inferences that tended to support two inconsistent propositions.
Ms. Wood, given the evidence regarding the condition and location of the firearm, couldn't the jury reasonably infer that it had been recently placed there?
Well, I think you have to look at the facts. So there was evidence that it was wet on one side and that one side was dry. It was July, it was the middle of the morning, and there was testimony that the firearm was seen the night before. And there was also testimony that it was seen in the morning, but there's periods of time where it was unaccounted for. I apologize.
Can you point, no, my fault. Can you point me to the record where it was seen the night before?
So it was seen the night before in Mr. Zorinsky's testimony. He had walked his dog around 11 o'clock. His statement is a little inconsistent. He talks about how he, I have it right here. Okay, so he walked his dog around 11 and said that it was an approximate time. He generally testified that he walked his dog, and it was his dog. His dog determined where he would walk. He wasn't specifically testifying to that night, but he did say he walked the dog. He was sure that he walked the dog that night. There was evidence that it rained that night. Mr. Zerinskis also didn't notate that it was raining that night when he had walked his dog. So there is a little conflicting information as to what time he walked the dog, or if he walked his dog late at night. So there is, I think those conflicting inferences leave a gap of time potentially that night or the next morning from the time he was last out there between 6 and 7:30 to the time that the firearm was found at 9 to 9:30.
Wait, I thought you said, and I thought Justice Hand's question was, where is there evidence that the witness saw the firearm the night before? And I didn't hear a response.
Oh, I
That was my
apologize.
question.
I apologize. The firearm was seen in the morning after the witness located it after he saw the cars drive by. So there was nobody who witnessed seeing it the night before. But that's just to give you a timeline that Mr. Zerinskis testified he did not see it when he was out the night before. So
Just to refresh your memory on my original question, which you were answering, and that is, why couldn't the jury reasonably infer that the gun had been recently placed there, given the location of the gun and the condition of the gun?
I think that they can reasonably infer it was placed there, but there's a gap in time as to this is a residential area, this is a morning, there are multiple people who could be walking. There's not an additional fact connect the defendant to this firearm. Yes, he drove by, but other people could have been driving, could have driven by, could have walked by. There's also a witness at the scene. So there needs to be an additional fact in order to make a reasonable inference.
What about him driving by the area where the gun was found because he was fleeing from the police?
Okay, so the flight is an issue, and I think that the flight is very important to weigh, and that it should be giving little weight, because the flight is really the evidence that connects potentially the defendant to this firearm. You need to look at the different chain of events that happened. The initial sighting of the detectives seeing Mr. Desir driving down Sprague Street. They were on a cross street. He looks to the left at a cross street. They say his eyes widened. They were 20 to 60 yards away, and for them to see in a tinted car window is, we would say, not probable. And the inferences need to be probable, not necessarily possible. And then, I'm sorry.
It's actually reasonable and possible and not necessary. And we have to look at the evidence in the light most favorable to the Commonwealth.
Yes, but it needs to be a fact that can adduce a probability that it happened.
So how the police officers testified they identified themselves and their badges were on display. Is that something that the jury could credit?
The jury could credit that if that was a testimony. The testimony actually at trial was that one of the officers didn't have time to pull out his, Detective Bell didn't have time to pull out his badge, and Detective Mercury said that he was pulling it out of his neck and didn't get it all the way out. So from a distance, one might not have seen the badge. And if you look at the where he was going, if he did see the police officers or didn't, at that point he was being followed. He was being followed by police officers in an unmarked car who were not, didn't have police clothing on. The car was not even a traditional police vehicle. It was a truck. There were no sirens. So when he continues driving and he drives to his home, which is does not show flight. He's going home to park his car. He shows patience. He's waiting for a car to pull out. And then he notices a car, the officers try to exit the vehicle at that point. Still at that point, there's no orders to stop. There's no verbal orders to stop. And they're still in plain clothes, and all of those things taken together do not suggest that stop occurred at that point. So Mr. Desir says later to the officers that he didn't realize it was officers, and that's the reason why he fled. And flight really needs to be considered here because it is the plus factor, I think, that really makes this case, and it should be given it should not be given great weight. It needs to be weighed in context of all the facts. Flight here, I did mention this in my reply, but the Warren case talks about flight, and there it dealt with reasonable suspicion and investigatory stop. And, while not the same, it did go into talking about why flight should not be considered should be given little weight as a plus factor. And the court cautioned that because they recognize the irony of no obligation to talk to the police or anyone for that matter, or how one could simply walk away, but yet flight itself is viewed as inculpatory. So
that's the study they referred to was in Boston, right?
Yes.
Has Warren been extended to anywhere beyond Boston?
Not to my knowledge, but I think that there has been reports and commissions in order to determine that, and one came out last week.
The problem is that none of that was litigated below, so we don't really have a record.
So we don't have a record, but we have some record on the flight. And I think you can still look at this analysis and viewing Warren, because flight is our issue. And the court in the motion for required finding did say that they considered that this case, they denied the motion because of the Jefferson case. And they said it was because flight put the plus factor over, and the court found sufficient evidence because of the flight. But the flight, if you look at Warren, really shouldn't be given much weight because it's not always probative of guilt. And sometimes it has more to do with a Black person, just the indicativeness of being racially profiled. This was detectives who weren't following him because he committed a crime. They were investigating another murder. They said that they had recognized him, and there's no testimony, there's no evidence that that was in fact true. So I think that the weight is really, the weight of the plus factor is important to look at, and because there is no additional fact to support that the flight was from guilt. There's nothing, there's no additional evidence tying Mr. Desir to the location. There's no fingerprints, there's no gun holster, there's no ammunition in his pocket. There's no additional evidence connecting him to this firearm. And the only thing that is really tying him and putting the sufficiency over is this flight. And that shouldn't be considered that should be given very little weight in light of the court's discussion of flight in the Warren case. So if that answers your question in a long-winded way. The lower court did deny the motion for required finding based on Jefferson. Just like to flesh that out, I did talk about this in my reply brief. And I just want to make the point that Jefferson is very different from our case because Jefferson was an actual stop. There were lights, there were sirens, and they made a traffic stop. And after that point, that is when the defendant accelerated at a high speed. It was February, his window was open, there was a broken firearm. So there are a lot of additional facts that tie that defendant to the firearm. We don't have any of that here. We don't have a stop. We don't have a lawful stop, and we don't have a, it's the middle of July. There's testimony that the window is at varying lengths open. This is a 4-inch firearm. To say that somebody threw a firearm that is not a small fire.
Isn't it significant that the gun is dry on one side and that it had rained, implying it had not been there very long?
I actually think that that shows that it had been there long, because it was a July day and it was there for multiple hours drying in the sun. So I think that it can show two inconsistent propositions, that the gun was there for a period of time. It wasn't a rainy, it was a rainy day and the next day was sunny in July.
Couldn't the jury, I understand that's the inference you draw from the evidence. Could the jury have drawn the opposite inference?
I think that it leads to speculation, and that's the problem. That there's not enough factual evidence to lead the jury to infer from the facts, that there's too much speculation and guesswork that the jury has to do to actually get to the end result here. And I think that's the problem with this case. There's just not sufficient evidence. I'd also like to point out there was a case on sufficiency recently. It was the Morera case, an unpublished decision by the appeals court. It's 97 Mass Appeals Court 1128. And basically it's not directly on point, but it's a sufficiency argument where there was drugs and a gun found in a home. And the court ruled that there was insufficient evidence because there were multiple people there and some other varying factors than our case, but they said that they couldn't tie the defendant to that particular firearm or the drugs. And I just briefly like to touch on—
I'm sorry, your time is up, Ms. Will.
I apologize. We rest on our brief and our reply.
Ms. Nguyen.
Thank you. May it please the court. My name is Mary Nguyen on behalf of the Commonwealth. With respect to the firearm and ammunition, taking all rational inferences in the favor of the Commonwealth, the evidence was more than sufficient to establish that the defendant possessed and then threw the firearm from his car, given the defendant's reaction to the presence of the police, which included his attempt to evade the police, the location of the gun and the defendant's flight path, and the condition of the gun. If I could discuss the location of the gun first. There was evidence that the gun was laying on the side of the street in plain view by a pole across the street from Mr. Zorinka's driveway in the area just minutes before he observed the defendant's car go by, followed by the detectives following behind 5 to 10 seconds later. The jury also received photos of the gun on the side of the road in plain view. There was testimony that was significant from Mr. Zorinska, testifying that he did not see the gun the night before or earlier that morning, nor had he seen the gun in all 46 years as a resident at that address. He significantly testified that no one else was outside when he observed the defendant's car go by, followed by the detectives following behind. So,
excuse me, how long after the defendant's car goes by is the gun discovered on the road?
So after it goes by, and then the defendant is stopped at the next intersection, the evidence is that Detective Ernie Bell is retracing the flight path and encounters Mr. Zorinska. Mr. Zorinska has a conversation with Detective Bell, and then Mr. Zorinska then locates the gun. So there's
it's not the next day.
It's not the next day. That's correct. So there's an inference that can be drawn that it was a few minutes, a couple of minutes after he observed the cars go by. So from that evidence, in the light most favorable to the Commonwealth, the jury reasonably could have inferred that its location in the defendant's flight path was, as the Jefferson case stated, consistent with where it would have landed had it not been thrown from the partially opened driver's side window of the defendant's motor vehicle at the moment when police briefly lost sight of it as the defendant drove in front of Mr. Zorinska's house. Additionally, the jury could also reasonably infer that it recently landed there because it was in the street in plain view, that it would not have remained there for long without it being reported or removed. And the photos are significant where you can clearly see that it's in plain view. And then next, if I could discuss the defendant's attempt to evade the police when they left their motor vehicle and began their approach to the defendant's car on foot. The evidence that the defendant made eye contact with Detective Mercurio as he and Detective Bell were approaching on foot, and then the defendant responded by speeding away with his engine revving, allowing himself to be momentarily out of sight when he drove by Mr. Zarinska's house. From that evidence, a rational jury could have also inferred that the defendant sped away for a reason, and also borrowing language from Jefferson, which both the motion to dismiss judge and the trial judge cited, that when the jury could have inferred that the defendant sped away for a reason when the detectives left their motor vehicle to approach the defendant's car, and that reason was to throw away the gun that the defendant feared the police would find during a stop. And they also reasonably could conclude that he sped away at that particular moment for a reason. And again, borrowing language from Jefferson, that reason was the defendant endeavored to conceal the gun by creating enough distance by fleeing, thereby creating a head start, creating enough distance to allow him to throw the gun out of the car window without being seen by the detective. And then next, if I could discuss the condition of the gun, where it was referenced that there was evidence that it was wet, where it was in contact with the ground, and then dry on the side away from the ground, despite the fact that surrounding grass and sand was wet from rain that had fallen the night before. No condensation on the magazine or the chamber of the gun, and evidence that there were scrape marks on the gun. So when you look at all of the circumstances taken together, that being the location of the gun, it being in plain view and located in the defendant's flight path, just moments after the defendant drove by, the defendant's attempt to evade the police when they left their motor vehicle and began their approach to the defendant on foot, in addition to the condition of the gun when it was recovered, based on the totality of that evidence in the light most favorable to the Commonwealth, which is the operable standard, a jury that would permit a rational fact finder to conclude beyond a reasonable doubt that the defendant knowingly possessed a firearm. And with respect to the ammunition, the fact that when it was recovered, that the gun was chambered in a position where it was ready to be fired, that was sufficient to establish that the defendant had knowledge that the gun had ammunition in it.
What's your best case for that evidence? What's your best case for the possession of the ammunition on the evidence in this case? For knowledge.
So Jefferson actually, in a footnote, makes a brief comment, and I actually didn't note this in my brief. I did cite the Grayson case in my brief for the proposition that the fact that a firearm is ready to be fired, you can infer the defendant's intent.
But that in Grayson, that was a factor. That wasn't the only. It wasn't saying that factor standing alone is sufficient, correct?
Just have a moment on that.
Sure. That's fine. If you want, I interrupted your answer to the rest of the question. So if you want to go ahead with that.
Okay, thank you. So I was just indicating that Jefferson in footnote 7 makes a brief reference where it says, to be convicted of unlawful possession of ammunition, the defendant must know that he possessed ammunition, whereas here the firearm was a revolver located in a vehicle. A rational jury could infer that those who possessed the firearm knew that it was loaded with ammunition. So that sort of is also what I believe it was the Grayson's case speaks of as well, for that proposition, that the fact that in our case, the gun was chambered ready in a position where it was ready to fire, that the defendant would have knowledge that there was ammunition in that firearm.
In this case, the firearm was not a revolver. Do I remember that correctly?
It was not a revolver.
So the ammunition wouldn't be visible necessarily from the outside of the firearm.
Correct. So from the light most favorable to the Commonwealth, the fact that you heard testimony from Ernie Bell, sort of the Detective Ernie Bell, that the steps that need to be taken with that specific firearm in order to get it chambered would suggest, in the light most favorable to the Commonwealth, that one would know that there was ammunition ready to be fired and chambered in that gun to support sufficiency with respect to knowledge of the ammunition in that firearm. And with respect to the defendant's reply brief regarding the Warren case, she acknowledges that that dealt with reasonable suspicion in the context of an investigatory stop, in the context of a motion to suppress. I would just respectfully request that the census information that she attached along with the Boston Police Department FIO study not be considered by this court, as it was outside of the record, not before not litigated below, not addressed on appeal, and that information was also not before the trial judge below. And
could I ask a question on the
Sure.
failure to stop charge with respect to the probable cause determination? Where will we find an indication that there was a signal by the police to stop?
so this, when you look at the totality of the circumstances, this is a situation where when you look at the detectives' actions, they followed behind the defendant and then they pulled behind his car, and then they exited and they began their approach to his car on foot, during which point Detective Mercurio displayed his police badge. Additionally, Detective Bell also had a police badge on his neck and his belt. And as they're walking to the car, there's testimony that eye contact is made between Detective Mercurio, who is displaying the badge on his neck, and the defendant. And the defendant, there's also evidence that the defendant is looking at the chest area of Detective Mercurio, where he's displaying his police badge. And that is in conjunction with evidence that the detectives have had previous encounters with the defendant, Detective Bell specifically.
But at that time, am I wrong about or am I mistaken that, at least as far as the police report goes, the clerk magistrate and the judge had evidence that the police were familiar through their police work with the defendant? It wasn't until trial that the evidence was more explicit about the fact that they'd had interactions face to face. Am I right about that, or am I missing
the evidence at trial? You're correct. With respect to Detective Bell, was that they were face to face interactions. In the four corners of the police report, I would respond that the information in there is still sufficient to connect, where you can make an inference that there were dealings, that the defendant had prior dealings with these detectives in their duties as police officers. So that based on that information, in conjunction with sort of what unfolded during the approach to the car, that those facts in combination permit a reasonable inference that the defendant was effectively notified that he was being told to stop by these detectives whom he had encountered before. And also, I don't think I mentioned this in my brief, but the very fact that the defendant disposes of the gun during his attempt to evade the police also permits the inference that the defendant knew he was being followed by the police, and he was trying to evade them, which also suggests that he was well aware that he was being followed by the police and that they were attempting to stop him. And I don't believe I have anything further to add. So thank you for your kind attention, and I respectfully request that the convictions be affirmed. If there are no further questions, the Commonwealth would rest on its brief.
Okay. Welcome to the Appeals Court. I'm Justice Mead. With me are Justices Kinder and Hand. The next two cases, 2019 P 1357 and 2019 P 1422, 21st Mortgage Corporation versus Lapham. Mr. Kia.
Justice Mead, Justice Kinder, Justice Hand, David Kaya for the appellant Karen Lapham. May it please the court. Your Honors, we've raised, I hear a little bit of feedback. I can work through that. We've raised three issues on appeal. The first one having to do with equitable subrogation, with no junior mortgagee intervening. It was a refinance mortgage where the refinancing mortgagee paid more to the person who applied for the loan than was necessary to pay off the previous existing loan. The second issue is the fact that the same person, after having deeded his interest to the property, to the locus, to his wife in pursuant to divorce proceedings, capitalized arrearages and escrow that he was required to pay and defaulted on paying pursuant to his separation agreement, and agreed with the lender, Washington Mutual, the successor to the lender, to expand the mortgage to secure additional capitalized amounts converted to principal after a time when he no longer had an interest in the property. And the third issue has to do with judicial estoppel ruling by the lower court. On the first issue, the model case that I have exhibited in the addendum is the Norwest versus McKinnon case. There's, as the land court, that was a land court case. In that case, Judge Piper pointed out that there was no appellate level decision on the issue of whether a refinancing mortgagee who pays a portion of the loan proceeds to discharge an existing loan is subrogated for further amounts. In the McKinnon case, there was two phases, basically, as I look at the case. The first phase was whether there was equitable subrogation. The court ruled that the new mortgagee was equitably subrogated to the extent necessary to avoid unjust enrichment. And that was the amount of the proceeds used to pay off the existing loan, but not the additional proceeds that the person who fraudulently applied for the loan, as if he was the sole owner. The second phase of the Norwest case was the plaintiffs asked for, they filed a motion for clarification and asked the court to declare that they had additional security, that they were subrogated for the additional amounts that were not used to discharge the existing loan. The court denied that, saying that that was not indicated in their complaint and considered it waived. However, the court said, I'll give you 30 days to file a motion to make that request. And the second phase of the case was lengthy. There was discovery, motion practice, and eventually in the second phase, the Norwest court found that in the circumstances of that case, in the particular circumstances of that case, they were entitled to equitable subrogate to an additional court-imposed second mortgage, but only on the 1/2 undivided interest of the person who applied for the loan, nothing further. That second phase did not happen in this case here. The land court's judgment simply said that Washington Mutual or Wells Fargo was the assignee at that time. The original lender was Washington Mutual. Wells Fargo was the assignee. Land court simply said that Wells Fargo is equitably subrogated to the position of the discharged Mansfield mortgage to the amount of $148,000 and whatever the change was. And so,
Mr. Kaya, let me interject a question if I can. 21st Mortgage says, and the judge in the housing court seemed to agree, that equitable subrogation affects the priority of a security interest in property, but has no bearing on the amount of the loan, which seems to be your client's issue, or at least one of the issues, an argument regarding the amount owed. Why is that incorrect?
The reason it's incorrect, Justice Mead, is because there's two considerations in an equitable subrogation situation such as this. One is priority and one is position. And the land court in McKinnon, in the Norwest case, used those terms. Priority refers to whether an intervening junior mortgagee is entitled to be put into first place or remains in second place. In the Ogun case, East Boston Savings versus Ogun, there was an intervening bank that paid proceeds to discharge the existing and also a private lender. And by first in time, first in right, on the record, they became the first position, first in priority. So what the Ogun court ruled there was based on the principles that Massachusetts is going to recognize for whether or not an intervening lender is going to be equitably subrogated or take first priority. Is a number of factors with equity and the behavior and conduct of the parties being one of the factors. Here, the reason why it doesn't encompass the full amount is because the amount necessary to avoid unjust enrichment, and I point to page 112 and 113 of the addendum in the McKinnon case. I'm sorry, it's a little bit difficult. I'm hearing myself feedback.
We can hear you loud and clear.
Okay. I'm just quoting from the McKinnon case here, where quoting Provident Company versus Provident Cooperative versus James Talcott, citing Jackson versus Boylston Mutual, where a first mortgage is discharged in the course of refinancing, the refinancing mortgagee steps into the shoes of the first mortgagee to the extent of the principal balance of the first mortgage. The extent of the principal balance of the first mortgage here was the 148, as the land court ruled. The court in Norwest went on to say, in other words, the new mortgage given by a mortgager who used the proceeds of the new mortgage to extinguish an earlier mortgage may receive the same priority once given to the earlier mortgage. And that's the Ogun case. And that was where there was an intervening junior mortgagee who was asserting the right to be in first position. The court in Ogun said, no, they're going to remain in second position because the discharging new mortgagee was equitably subrogated and under the facts of that case entitled to be first priority.
And how does all of that affect the housing court's judgment of possession for 21st mortgage as to whether or not 21st mortgage has legal title to the property?
How it affects it is our position was that the precedent set in the Norwest case is almost a perfect template for how the court ruled here. Wells Fargo did not take the additional step of asking for additional security. They, in this case here, 21st Mortgage made the argument that we started with security on a 1/2 undivided interest, and the land court gave us more security on the other 1/2 undivided interest. The defendant here, the appellant here, Karen Lapham. And what we're saying is she was entitled, according to the land court judgment, to be put into the same position as she was in prior to her husband at the time applying for another mortgage and doing it on his own. If I could get to the other issues briefly, unless Your Honor has any other questions about.
Oh, please proceed.
In the second issue, on page On page 385 of the brief in the addendum, or of the appendix, I beg your pardon, we see that it says that this is agreement to 387. In consideration of the amounts and covenants hereafter, basically what this is saying is that the security agreement is extended. The date of this is July 27, 2008. And what happened was Karen Lapham's husband, Arthur, after their divorce, was required in according to their separation agreement to make payments on the mortgage until their youngest child graduated from high school. He made a couple of payments, defaulted, and there was accrued interest and escrow. And what he and Wells Fargo agreed to do, agreed in quotes, was to expand the mortgage security interest to cover the capitalization of those accrued interest and escrow arrearages. It's a situation of somebody agreeing to further encumber, further mortgage a house that doesn't belong to him anymore. And that was part of the amount that was included in the gross amount that was alleged to have been secured and the power of sale invoked on. And our argument is that's void.
Wasn't, is there, you say it's void, but was there any legal prohibition within the mortgage document that would prevent the borrower from modifying the loan with the lender?
I know of nothing in this mortgage or of any other mortgage that allows somebody to encumber a property that doesn't belong to him. In this case, to further encumber it with a further capitalized principal. So in other words, if I have a mortgage and I deed my interest to somebody else, and then I want to borrow more money from a lender, they agree to lend it to me, and they tell me, well, as long as you agree to sign this extension agreement to expand the mortgage, that you expand the mortgage of the house that you deeded to somebody else that you no longer own, and I agree to own that, that can't be a valid contract for me to be able to do that. I can't encumber a house that doesn't belong to me anymore. And I would ask for a standard of review of that the court take an independent review of these documents of the modification agreement and the statement of counsel in the transcript, who confirmed that this was a modification of a security instrument.
Mr. Kaya, before you run out of time, I want to ask you a question about the judicial estoppel argument. Do you agree that your client took the position in the land court that she was not a party to the mortgage?
I would agree with that, Your Honor. However, with the judgment of equitable subrogation, let me step back. Prior to the judgment, at law, she had her 1/2 undivided interest free and clear. And equitable subrogation is under principles of fairness. It wouldn't be fair for her to have the property free and clear because of fraud or mistake. So the judgment of equitable subrogation said, we're putting you in the same position you were in before. That's what you knowingly agreed to commit yourself to. And as far as judicial estoppel, by her saying, I'm entitled to notices of default under the contract, under the Mansfield mortgage, and that are afforded to me under statute, that is not taking a directly contrary position.
But wasn't her position originally in the land court that she was not a mortgagor and therefore not bound by the terms of the mortgage?
She was. However, through her counsel, she agreed that equitable subrogation was an appropriate remedy to the situation. She resisted being bound to the amounts that were, the additional amounts that were borrowed by her husband, for which she obtained no benefit from, and agreed to be bound by what she had originally knowingly committed herself to in the Mansfield mortgage. And therefore, if she is agreeing to be bound by that mortgage that Wells Fargo stepped into the shoes of, then it's only fitting and equitable that she's entitled to all of the contractual protections and statutory protections as a mortgagor because her property was mortgaged. If she agreed that her property was mortgaged to the extent to avoid unjust enrichment, then at least equitably she is a mortgagor, if not under the new refinancing loan given by Washington Mutual to Arthur Lapham. It's not a directly contrary position, which is the first element required. The additional thing I would say about that is that Karen Lapham and Wells Fargo agreed to settle. Wells Fargo could have gone to trial, as the land court judge said, on the issue of whether there was a mutual mistake, and they elected not to go to trial. So she did not convince the court of anything over the objection of Wells Fargo. So it was a settlement. They agreed to settle to a judgment of equitable subrogation. She agreed to have her interest encumbered. So therefore, at least equitably, she is a mortgagor. And I think the court in Norwest says that when a new refinancing lender pays off and discharges an existing mortgage, they step into the shoes of that existing mortgagee as if it was an assignment. So
thank you, Mr. Kai. I think you've answered my question.
You're out of time.
Thank you very much, Justice Mead.
Ms. Swisher.
Good morning, Meredith Swisher on behalf of 21st Mortgage Corporation. I will argue for the first 5 minutes on the first argument set forth in 21st Mortgage's brief, with on the argument concerning the 2012 land court judgment, with the remaining time and arguments deferred to co-counsel Michael Hagopian. It's 21st Mortgage's position that the housing court correctly found that the 2012 land court judgment did not impact the loan or the servicing of the loan. It simply established the extent of the first priority security interest in the property. The 2012 land court judgment, importantly, did not impact the validity of the 2005 mortgage on a 1/2 interest in the property. Ms. Lapham's reliance on the Norwest case is entirely misplaced. In that case, a brother and sister owned property as joint tenants, and the brother forged a deed so that he would become the sole owner of the property, and then he went out and granted a mortgage. That entire transaction was grounded in a forged deed and in fraud. And under those circumstances, because a forgery conveys no title, the mortgage was not valid on the property. So the only thing that was before the court was the lender's equitable interest in the property. The facts that were present in the Norwest case are not present here. Here, the material facts are very straightforward. Arthur and Karen Lapham, who were married at the time, acquired an interest in the property back in 1992 as tenants by the entirety. That never changed until their divorce. They refinanced several times. They refinanced in 2002 through a mortgage that they both granted to Mansfield Mortgage Corporation. That
Ms.
Mansfield
Swisher,
mortgage.
Can I interrupt with a question,
Yes.
please?
Yes.
What's been troubling me a little bit in this case, or I've been trying to get my hands around, is how the notice of balance due received from 21st Mortgage to Ms. Lapham is in the amount of $309,987, which of course far exceeds the original loan amount. How did your client arrive at that number?
So that's a question that would be deferred to Mr. Hagopian. Your Honor, my portion of the argument is solely on the equitable subrogation judgment.
Right.
I would only answer that the loan was in default for many, many years. So it was originally a $191,000 mortgage. They defaulted in 2007 and kept defaulting, and ultimately the title defect was discovered in 2010, but the foreclosure sale did not occur until 2017. The key law that governs the validity of the 2005 mortgage is the Caraccio case, which held that a spouse that holds a property as attended by the entirety may encumber his or her interest in the property without the permission of or the knowledge of the other spouse. And so under that law, Arthur Lapham was free to encumber his interest in the property. So there's no question that he did that. And the Caraccio case also held that the bank could foreclose that interest. When they divorced, that tenancy by the entirety by operation of law was converted to a tenancy in common. So the 2005 mortgage automatically attached to a 50% interest in the property. When Wells Fargo discovered the title defect in that Karen Lapham, who signed the mortgage, but whose name was not in the granting clause on the first page of the mortgage, when they discovered that defect, they filed a straightforward quiet title action in the land court, seeking only to encumber her interest in the property. The land court complaint, which is only 5 pages at page 177 in the record, clearly pleads that Wells Fargo intended to uncover the entire property. The mortgage does not uncover the entire property, and they seek to encumber it under 2 theories: either reform the mortgage so that her interest is encumbered by the 2005 mortgage, or alternatively, to obtain equitable subrogation as to her 1/2 interest. That's what the land court granted. The equitable subrogation judgment that ultimately the parties agreed to, and it became a final judgment, is unambiguous, but it only establishes the extent of the security that could possibly be on her interest in the property. It doesn't impact what was on his interest in the property. And all the arguments that she's raised about the debt, those are all secured only by his interest of the property. Her interest in the property is free and clear of that. And she's only encumbered by the $148,000 and change equitable subrogation judgment. Does the court have any questions about the land court action that I could answer in the last 30 seconds?
No.
Okay. Then I will defer the remaining argument. Yep.
Thank you. Mr. Hagopian.
Good morning, Your Honors. Michael Hagopian, representing 21st Mortgage. Your Honors, the appellant's theory throughout this case, as well as the housing court below, is that she should be treated as a borrower or a mortgagor. However, she was neither a mortgagor nor a borrower. Mr. Latham was the only borrower on the promissory note and the only one obligated to pay the amounts that were due. There was an opportunity for her to agree to reform the mortgage and receive all the benefits of the mortgage in the land court. However, she strenuously opposed any obligation as a borrower or mortgagor in the land court. This court should consider whether Karen Latham even has standing to put these arguments before the court. The housing court correctly held that Karen Latham was not a borrower, which puts her standing to challenge the notices issued during the foreclosure process in question.
Mr. Hagopian, let me ask you about that. That is essentially the judicial estoppel argument, correct?
Correct.
Assuming we were to find that judicial estoppel applied in this case and that the housing court judge was correct, does it apply across the board to all of Ms. Lapham's claims?
It does, Your Honor. For starters, we would look at basically 3 types of notice. The 244-14 notice, which was strictly complied with. 244-14 requires the lender to give a notice of the foreclosure sale to all owners of the property. Ms. Latham, as an owner of the property, was entitled to that statutory notice. There is no dispute or any contradiction that she received such notice. The notices regarding 35A, again, only apply to a borrower. And as the Supreme Judicial Court had held in Schumacher, it is not fatal in and of itself, even if she was entitled to a 35 notice. If she hadn't received one, it's not fatal to the foreclosure because that is not one of the statutes that is related to the foreclosure process.
But as I understand it, your argument is it really doesn't matter whether she received notice or not.
Correct.
Because she's not a borrower.
Correct. And the reason I bring that up, because even if she was entitled to notice, correct. She was not entitled to notice because she was not a borrower.
And there was also there was a counterclaim for 93A violation. Does the judicial estoppel argument apply to that as well?
The housing court found that, first of all, the the affidavit was full of conclusory statements and did not support her claim for 93A, and that she wasn't entitled to bring those. But nonetheless, the housing court did hold that those claims did not in any way void the foreclosure sale. And I would agree that the housing court judge was correct, and that those issues, especially raised in the guise of a 93A, do not rise to the level to which would void a foreclosure sale. The third, so you have the 35A, the 244-14, and the third notice would be the notice under the terms of the contract. And I think it's important for this court to note that the whole land court case was brought because Ms. Latham did not properly execute the mortgage, and the mortgage was not effective against her. Otherwise, it would not be necessary to have equitable subrogation. In granting the equitable subrogation, as the housing court judge noted, the loan, the servicing, the loan documents, nothing was modified. There was no modification of any of these documents. That would be including the mortgage. Now, since Ms. Latham was not a party and not in privity of contract with the lender, she was not entitled to any notices that were set forth in the mortgage. Her position in the land court that she was not a borrower or a mortgagor is now, she now takes a contrary position in the housing court and says that, well, I wasn't a mortgagor, I want to be treated as a mortgagor, and I should have received notice under the contract. But yet she wasn't in privity of the contract, and nothing included in the land court order changed that.
Didn't 21st Mortgage argue in the land court that she in fact was a borrower and was a party to the mortgage?
That was one of the positions that it took, and seeking to reform the mortgage. But the mortgage was never reformed, and she was never added as a mortgagor or a borrower under the terms of the mortgage. And without privity of contract, she can't be subject to the terms of the contract, which is why it was necessary for the equitable subrogation order.
Let me ask you the same question I asked Ms. Swisher regarding the $309,000 roughly. Is Ms. Lapham on the hook for that amount?
No, she's not a borrower. Her interest was capped by the land court at the $148,000. So her interest in the property was capped. Now, again, Mr. Lapham still had an interest that was subject to the mortgage because he took out the mortgage before. And that interest that he had was conveyed to Ms. Lapham. But she is not on the hook because she was not a borrower.
So if the property is sold, the $148,000 that is the equitable subrogation judgment would be satisfied with the proceeds, and also whatever Mr. Lapham's obligation is.
Correct. And if I can touch upon very briefly the argument about the modification. The defendant goes through great lengths, and Mr. Kia spent a considerable amount of time talking about the modification of the mortgage. This court should be aware that the mortgage was modified at a very small amount. It was about $6,800. The amount that was modified was not to extend any additional sums to Mr. Latham. No, it was approximately $2,000 that was owed in accrued interest, and approximately another $4,000 in taxes and interest. So those were amounts that were already due under the mortgage. They weren't a new extension of credit. Mr. Lapham and the property, to the extent it was secured by the mortgage, were already subject to the accrued interest, and interest had it additionally accrued, and the taxes and property insurance that were advanced by the lender. which under the terms of the mortgage, they were entitled to recover.
And what about Mr. Kaya's argument that Mr. Lapham was not entitled to further encumber property that he did not own?
The mortgage was still attached at the time he owned it. When he transferred his interest to Mrs. Lapham through the divorce proceeding, she took subject to any encumbrance that he had on the property. So while he may have divested his interest in the property was still subject to the mortgage. And I would add that notwithstanding the modification, the land court order was also very clear that regardless of whether it was modified, Ms. Lapham's interest was still capped at $148,000. So if it had been modified and even additional sums had been advanced, it wouldn't change the security on her interest because it was capped. And I think it's important to know that the modification was before the land court proceeding. She knew about that at the time of the land court judgment, never raised it during the land court proceedings at all, and only raised it, after the fact. Your Honor, in this action, Karen Latham's continues to attempt to set aside a foreclosure sale of the Washington Mutual mortgage, the failure to treat her as a borrower. It's inconsistent with her position in the land court, where she actively opposed being a party to the mortgage. She was not and should not be treated as a borrower, and since she was not a borrower and the mortgage was not reformed, she should not be treated as such. Her property was used as collateral for a note that was used to pay off an obligation that she was obligated to pay, and it was capped at that amount. She was given the statutory notice of the foreclosure and had an opportunity to cure the default. For those reasons, we ask that the decision of the housing court be affirmed. Thank you.
Thank you, Mr. Gopian. We're going to have Ms. Swisher go into the waiting room, and then we'll begin argument on 1422. Mr. Hagopian, as soon as the timer shows up.
If I could just have one moment.
Of course. Go right ahead.
Thank you, Your Honors. Michael Hagopian, attorney for 21st Mortgage, the appellant in this issue regarding the application of a use and occupancy bond. The matter before the court derives from a post-foreclosure eviction action where judgment for possession entered in favor of the plaintiff. Defendant appealed that decision, and a hearing was conducted on the issue of the issuance of an appeal bond for use and occupancy payments.
Mr. Hagopian, maybe I could sort of leap forward here and get to a point where I think there may be some agreement. As I understand Mr. Kaya's response, he concedes that King controls and that the order of the single justice therefore must be set aside. But in a separate pleading, he suggests that the matter be remanded to the single justice, apparently to take evidence or hear further argument regarding the use and occupancy amount. First, have I correctly stated the procedural posture? And second, what's your position on a remand?
On a remand, Your Honor, it would not be to the single justice. If there were to be any remand, it would be to the housing court. The housing court held a full and fair hearing on the issue. There would be no further evidentiary hearing before the single justice. Had the single justice not ruled the way he did and not followed and did not follow the Dundon case, the review would have been on the reasonableness of the bond. That would have been based on the record in the housing court. So this court, on review, can take the issue de novo and review the record of the housing court. In fact, there was sufficient evidence before the housing court to establish the use and occupancy at the $2,200 per month. The defendant, as a tenant at sufferance, was obligated to pay use and occupancy despite the fact that the appeal bond was waived due to indigency. Indigency in and of itself is not a reason for no use and occupancy. And the King Court was quite clear on that.
Mr. Kaya suggests that one of the things that occurred at the single justice hearing was at least an effort on Ms. Lapham's part to offer documentary evidence regarding the condition of the premises. And he apparently seeks a remand for the purpose of asking the judge to make a decision on that. First, were you present at the single justice hearing? And if so, what's your recollection of what the single justice ruled with respect to the admissibility of that evidence?
Your Honor, I was not present at that hearing. I wasn't with the firm at the time. I don't believe I was with the firm at the time, but I was not at that argument. However, that was an appeal. That was an appeal of the housing court, and the appeal is limited to the record before the appellate court, and that the single justice at that time should have only considered, his review should have been limited to the record from the housing court. Again, this court can examine that record as well. The King Court did list several factors for the court to rely on in deciding whether the amount of the bond was fair to both sides. Those factors would be fair rental value of the property, merits of the defense, the amount owed on the mortgage, the number of months in which no money was paid on the mortgage, expected duration of the litigation, and the respective financial conditions of the parties. All of this was considered below. And that there is a sufficient record before this court for the court to review those factors based on the only evidence that was before the court, that being whether the $2,200 was fair to both parties.
Was there any evidence before the housing court judge that Ms. Lapham contested the fair market rental value of the property?
My reading of the record is that she did, and that was reflected in, I believe it was reflected in the court's decision. However, it was vague. She talked about drafts, she talked about some squirrels, she talked about some property conditions. However, it was never quantified how those issues reduced the fair market rental value of the property. To the contrary, plaintiff put forth expert testimony, a realtor who had viewed the property, had viewed the comparable rentals in the area, and made a determination, which the court credited, that the fair market rental value of this property in this neighborhood was $2,200 a month. There was no contradictory value put forth by the defendant. Speculation on her part and vague issues in and of themselves don't provide the court with any direction as far as reducing that value. And that's the record that was established. And that is the record upon which Judge Taplin made her decision. In fact, the defendant even conceded, had put forth evidence about the HUD market value, which is more of a vague value, but it's not that far off from what the plaintiff had put forth from a more detailed market analysis of the rents in the area. Defendant's only substantive objection to use and occupancy was her ability to pay. I believe her testimony was, or she put forth before the housing court, that she was on assistance, received a small amount of money per month, and that was unable to pay such a large sum. She was also caring for, I believe it was some grandchildren. And while that may be one factor for the court to consider, the the King Court in the SJC's decision in the King Court very clearly stated that inability to pay is not in and of itself a reason to waive the bond. The duty of care for a person who is either poor or unable to pay or needy is on the state, not on the landlord. So it is not a reason to waive the bond. It's not a reason to reduce the bond. It is only one factor for the court to consider. And I should take back, the court could reduce the bond, but it's not obligated to do so. And I believe in the King Court, the court even went on to the fact that the borrower wasn't able to afford the mortgage for quite a long period of time. And even though that was unfortunate, it didn't change matters. And that they were still required to pay the fair market value of the property, the use and occupancy pending appeal.
And is your view that our review of what the single justice did, and before the single justice, the housing court, that it is a de novo review?
According to the King Court, it is a de novo review. The standard is a de novo review of the housing court order. And this court can consider the findings, the amount of the bond, and the amount of periodic payments. And in addition, Your Honors, some of the other factors to consider when evaluating the use and occupancy is the principal and interest of the note, which in this case was approximately $1,100, and taxes and insurance. And Judge Kinder, you had mentioned this in the last argument about the amounts that were due. If you look at the 35A letter that was given to Mr. Lapham, there are a considerable number of tax payments that were made by the lender prior to the foreclosure, and they continued to do so. So basically, Ms. Latham was living there, not only not paying the mortgage, but she wasn't paying the taxes of the insurance. And of course, those all became due as part of the past due amount on Mr. Lapham's obligation to pay the note. So this court is able to consider the fact that the principal interest payments on the note had been paid since, I believe it was 2010, and taxes in the amount of $1,200 per quarter were not paid, but were paid by the lender and continue to be paid by the lender, and have been paid by the lender since the case has been on appeal. Based on all of those factors set forth in King, the housing court's determination that fair use and occupancy in the sum of $2,200 was appropriate and supported not only by the law, but by the uncontradicted evidence that was before the housing court. And I don't believe that it should be remanded to reopen that hearing, because she had a full and fair opportunity to address that at the time the use and occupancy hearing was held. Ms. Latham should be required to pay use and occupancy retroactive to the date of the judgment as a condition of appeal before any decision is reached, in this case, on the merits. Your Honor, unless you have any other questions, I will rest on my brief.
Thank you.
Seeing none, thank you. Mr. Kaya. You need to unmute your mic.
Sorry about that.
It's okay.
Thank you, Your Honors. Okay, there I am. I just had trouble with Zoom there for a second. Your Honors, if Karen Lapham did not qualify as indigent pre-King, the issue that would have been argued, the challenge before the single justice would have been solely a challenge to the ordered monthly use and occupancy payment of $2,200 a month. Because we had the Dundon decision pre-King in that any person qualifying as indigent was excused from paying use and occupancy. That was what was put forward, and that was mainly what was argued. However, in this hearing, I did present pictures and descriptions of the significant repairs that are needed to this property. She did not upkeep the property because she didn't know if she owned it or not. She didn't know if she was going to be dispossessed of it or not. So there's a lot of things wrong with the house, and it's the purpose of this session here is not to go into that, but merely say that everybody that is aggrieved, I would point the court to chapter 239, section 5, F and G. F says any party aggrieved by the denial of a motion to waive the bond. So that ship has already sailed. She no longer gets a waiver of the bond or use and occupancy payment. So it's as if we're starting from a position now back to the single justice, and that's what I'm arguing that she's entitled to, is a remand back to the single justice to have her statutory opportunity that is given to anybody in this position under 239.5. And
typically, though, Mr. Kaya, hearings before the single justice are not evidentiary in nature. And Mr. Hagopian suggests if there were to be any remand, it shouldn't be to the single justice, but to the housing court. What's your position with respect to that?
I respectfully disagree with that because as Your Honor pointed out, it is a de novo hearing. And under F, under G rather, it says any party to the action may file a request for a review with the clerk of the court. And it says that the court shall then forward the motion, findings, and any other documents relevant to the appeal. And at the last paragraph, it says any request for review filed pursuant to this section shall be heard upon statements of counsel, memoranda, and affidavits submitted by the parties. Further testimony shall be taken if the reviewing court shall find that the taking of further testimony would aid the disposition of the review. So I would point to that as my support that further evidence can be taken if the single justice deems it appropriate. And
because our review of the issue is de novo, and we have the entirety of the record before the housing court and the single justice, why shouldn't we just address the matter ourselves?
You mean this panel that
Correct.
You're sitting on?
Correct.
Because the procedure in 239.5 is that the single justice determines whether the amount is fair. And I could put together the pictures of the conditions of the house that show the damage. Mr. Rossi, the realtor, I don't know what he did, whether he drove by the property or he just looked in MLS comparables to see what the rental value was and made his calculus based on that. But there is significant.
But didn't you already have an opportunity to challenge his market assessment of the fair rental value before the housing court? And in fact, you submitted some evidence with respect to conditions, did you not?
In the housing court, I did not, Your Honor. I did in the single justice hearing before Justice Runo, and I offered the pictures and the description, and she declined to accept it. And
well, my recollection of that is that Justice Vuno took under advisement your offer of evidence. The record reflects that that evidence, those documents are not part of the single justice record. Can't we infer from that their admission was denied by the single justice?
I wouldn't, respectfully, I would not infer that there was a denial. As an officer of the court, she did not say plainly, your request to submit pictures and documentary description is not accepted. The bottom line is that the issue of conditions and the challenge to whether or not the $2,200 amount was fair was moot, because Justice Funo ultimately decided under Dundon that she was excused from paying based on her indigency status. The issue of conditions and the fairness of the amount was not addressed at all. And what I'm saying is that Karen Lapham, as somebody in this position, as if she was not indigent pre-King, should have a full and fair opportunity to have the conditions and the fairness of the amount decided on. And there's plenary opportunity for that provided for in section 5 F and G, subsections F and G. And she hasn't had that because I don't know how Justice Funo deliberated, but obviously at the time she decided, I don't need to go into conditions and fairness of the amount because I'm ultimately deciding that Dundon controls and she doesn't have to pay anything. Obviously that was vacated, and now we're back in the same position we would have been had she not been indigent. And Karen Lapham has a right under 239.5 to have that decided on and deliberated upon by the single justice, and to have the conditions evidence presented de novo be fully considered.
Thank you.
Thank you, Your Honor. If there are any other questions, be happy to answer them.
Seeing none, we will take this under advisement. Thank you. Thank you both.
Thank you, Your Honor.